welcome back. Thank you for coming back. Hello to all the streamers. We've still got lots and lots of people dialing in, and that's because we believe in finishing these things strong. No limping off into the sunset. I might limp off into the sunset later on. Anyway, listen, our keynote speaker is Head of Consumer Insight and Policy for Consumer Investments at the FCA. She's going to come on and give us about 25 minutes of prepared remarks, and then we're going to do questions. I'd really like to fill up the questions as she's speaking so that we don't have that long. We've only got 15 minutes. So please use the chat at home or in the room and get your questions coming in, and then I'll be nice and prepared. I'll come back on, and Kate and I will have a chat. So please give a very warm welcome to Kate Blatchford-Hick.
Thank you ever so much for inviting me along today. I'm Kate Blatchford-Hick. I'm Head of Consumer Investments, Market Analysis and Policy at the FCA. Sort of regretting not doing a drama A-level being up on this stage. It's been a while since I've been on a stage as big as this, but really happy to be here and to talk you through some of the policy priorities that we have at the FCA. So the theme of the conference today is Regenerate. We're here to consider the future and what that might look like for the sector. I was asked to talk about the FCA's vision for the consumer investment sector, and given my particular area of responsibility at the FCA, the role for policy in helping to shape that vision. Handily, we gave some thought to this at the balance the three following factors. First, it must meet clear consumer need at a price they're willing to pay. It must provide consumers with appropriate levels of protection. And finally, it must be commercially appealing to firms who want to deliver it. We published a policy paper at the end of last year, and that paper sets out our early stage thinking. It includes putting forward 3 proposals to expand that diversity of supply to consumers. It's worth noting it's an early stage paper. That means none of our proposals are at the moment set in stone. It's our initial thinking, and we really want the paper to prompt discussion. We welcome any other ideas that you have that you think we may have missed or not fully explored, as that will help us develop our thinking further as well. So I'll take a closer look now at those 3 policy proposals. The first proposal is perhaps the simplest. Before we start coming up for ideas about new regimes, we want to ensure that the existing framework works as effectively as possible. We know we need to create new avenues for firms to provide mass market consumers with support. However, we understand that firms are cautious about delivering guidance services too close to the boundary. We're often told this is due to fear that they might unintentionally move into delivering regulated advice. This caution leaves a gap of potential guidance-based support. So the central tenet of our first proposal is to try and narrow that gap. Last August, we published a boundary clarification document to give industry more certainty on what they can do without crossing that boundary. We want to hear from you if there are more scenarios where you feel constrained from supporting consumers and would value clarity from the regulator. We need this industry input to take forward this proposal, as any guidance or further insight from the regulator would be based on real-world examples where firms continue to feel that lack of clarity. There's some options available to us. We could provide new guidance, or we could perhaps simplify the existing guidance to explain what support firms can offer. Any work would be underpinned by the consumer duty, particularly the requirement on firms to avoid causing foreseeable harm to consumers. For example, our August boundary clarification highlighted how firms can, under the duty, outline the unintended adverse consequence for a consumer withdrawing funds from their pension too early. Firms could also warn of the potential risks of stopping or reducing pension contributions. Our proposals would expand on where we expect firms to comply with the consumer duty and where they can do so in a way that doesn't amount to giving a personal recommendation. So that's the first proposal, more clarification on the boundary. The second is what we're calling targeted support. It's a proposal for a new type of support, and it's perhaps the most exciting of our 3 proposals, and the one that is perhaps the most genuinely innovative. We're proposing the premise of better, not best, when it comes to targeted support. And the essence is to provide consumers with suggestions to get them to better outcomes in managing their money. We recognise that targeted support would not be as bespoke as simplified or holistic advice. In taking forward the thinking on what targeted support could look like, we're considering a number of policy issues. I'll outline 5 of those now. The first is the scope of the service. We have an ambition that targeted support would provide support which is widely accessible to mass market consumers across their investment and pension decisions, including decumulation. Second, the standards that would apply, including product governance. We're considering putting in place a new standard to facilitate targeted support. So instead of being a personal recommendation based on you, we're exploring targeted support being a suggestion based on people like you, which would allow firms to base the support on more limited information about the customer. Thirdly, fees and charges. We're exploring options which enable targeted support to be offered without explicit upfront charges, although the cost of any service would need to remain transparent through the consumer journey. Fourthly, consumer protections. We are working through what robust protections will need to be in place to protect consumers to ensure good outcomes. This includes how firms will need to communicate to consumers so they understand the services they are signing up to. It will be critical for consumers to understand what targeted support is and, importantly, what it is not. And then finally, the regulatory framework. We're considering which regulatory mechanisms, including potential legislation, needs to underpin any new regime. We need that regime to work in a way that works for us as the regulator, for consumers and for firms as well. And then finally, simplified advice. The concept here is of a more streamlined, more straightforward advice service offering. The aim would be to meet the more basic needs of mass market consumers. We envisage that it would be transactional, one-off advice, specific to a point in time and a specific client need. The initial thoughts that we have for this regime are first, it would exclude advice on decumulation in retirement. Currently, when giving this advice, a firm needs to know quite a lot about a customer's financial and personal circumstances. So we think there are challenges in simplifying this in a way that is practical and results in a personal recommendation. So the regime at the moment is focused on supporting customers with a specific need at a point in time outside of decumulation. You'll be well aware that we have separate ongoing work reviewing how firms are delivering retirement income advice. We'll be publishing our findings on that later this quarter. And then secondly, we propose that simplified advice would not include ongoing advice or a periodic review service. And finally, we propose it would be delivered by advisors with proportionately fewer qualifications given the narrower, simpler scope. We are aware, of course, that this is not the first time we've considered simplified advice, which to date has not been widely adopted. However, this time, post-Brexit, we have more freedom to design a regime that works for UK consumers and firms. It is our intention at the FCA to make the best use of this opportunity. We also recognise that the propositions offered by firms and demand by consumers may continue to evolve. So by providing targeted support, it may lead to a greater market for simplified advice emerging over time. So to summarise, we encourage you to engage with this paper and share your thoughts on our 3 proposals. We think it's a real opportunity for you to help us shape the regime which will support consumers well into the future. So to return to our vision of the consumer investment sector, I've talked about 2 features of that vision. The third is about having a realistic approach to risk. And this is an area where we think our expectations of firms are clear, particularly in light of the consumer duty expectations that firms help consumers understand the products and services they sign up to. But we have seen some examples of poor practice, and we need to call these out. We recognise that there will always be uncertainty and risk when investing. Consumers who want to invest need to know that they are taking risk to achieve greater returns than they may get through a savings account. They should only invest if they are comfortable with that, accepting that the value of their investments may decrease. Regulation should support consumers to distinguish between legitimate investment risk and fraudulent products. Consumers can only be expected to take responsibility where firms enable them to understand the features and the risks of the products being offered, and to understand the implications of any decisions that they make. Our work at the regulator needs to ensure that this is the case. You will, of course, heard us speak about the Consumer Duty products and services outcome. We want all products and services for consumers to be fit for purpose. They should be designed to meet the needs, characteristics, and objectives of a target group of consumers and distributed appropriately. They should work as expected and be sold to the right people. We've seen plenty of good examples of firms thinking about the products and services that they offer. This has led many to make changes to the benefit of clients. And it's often gone hand in hand with firms thinking about the value offered. Some firms have made changes to their pricing structure, for example, which has benefited many consumers. However, we've also seen examples of complex products and services being marketed to the wrong consumers. We have seen cases where the risks being taken by consumers do not appear worth the potential rewards that they could receive. We called this out in a letter to wealth management firms last November. We were disappointed to see examples of some firms taking advantage of their established relationship with clients. They did this by obscuring the risks of unsuitable portfolios which were not aligned to their client's risk profile, behaviour that was clearly at odds with the objective of the Consumer Duty. We've also seen some execution-only stockbrokers promoting products that are too complex to understand, again at odds with the consumer understanding outcome of the Consumer Duty. We want consumers to be given the information they need at the right time in a way that consumers can understand. It's not about scaring consumers away from taking any risk. It's about understanding the risks that they are taking. So this leads me on to the fourth feature of a well-functioning consumer investment sector, the importance of having useful information. One of the things that keeps me up at night is how we are going to ensure at the FCA that our policies are positively reinforcing and support consumers in the round. Our advice guidance proposals focus on providing consumers with the right support to help with their financial planning. That experience needs to be supported by consumers having the right information to choose between specific investment products. Such information needs to be proportionate to the complexity of the investment and given at the right time. We need to make sure consumers are not overloaded or put off. We are thinking about consumers' information needs as part of the advice guidance boundary, but that is only one part of the picture, and we need to look at product disclosure more broadly. We recognise that we have a key role when it comes to useful information. Making sure firms communicate well with consumers is central to our policy work. A significant proportion of current UK rules are drawn from the EU's regulation on packaged retail and insurance-based products, or PRIPS for short. Post-Brexit, the Treasury is committed to retiring the PRIPS regime. They have published an illustrative statutory instrument on the mechanics of transferring rule-making powers over to a new retail disclosure regime for the FCA. This will provide us with a good opportunity to design and deliver a flexible, proportionate regime that supports retail investors to purchase products that suit their needs. We also consider it as an opportunity to ensure that there is a flexible and proportionate approach to regulation in this area, which is tailored to the UK market. Our work reforming the disclosure regime will be supported by the outcomes-based objective of the Consumer Duty. We hope this will allow us to move away from unnecessary prescription towards firms providing information to consumers, which is engaging. A consultation on proposed new rules for product disclosure is currently being worked on. We hope to publish this in the first half of the year. However, even when there are the best intentions from all parties, things can go wrong. So this brings me on to the final feature highlighted by our vision, appropriate protection for consumers. We want to ensure that there are proportionate frameworks in place to put things right when things do go wrong. We are aware that the topic of redress and compensation is a topic of interest to many firms. To give you a few facts about redress in our sector, £760 million worth of compensation was paid out by personal investment firms that left the market between 2016 and 2022. 95% of this redress liability was created by just 75 firms. This compensation impacted 20,000 consumers with an average compensation payout of £38,000. As you know, these costs are met by the firms that remain in the market, and we know that for many small firms, FSCS costs form a significant part of your regulatory levies. This is the reason why many stakeholders have been calling on us to do more to ensure that the polluter pays where there is misconduct. We've already taken steps to move closer to this principle. Anyone following our work on the British Steel pension scheme will have hopefully seen that we have started to publish enforcement notices against firms and individuals. This includes us instructing several individuals to pay money into the FSCS to help meet the cost of the redress bill that they caused. However, we recognise that there is more for us to do, and this is where our current consultation on the proposed capital deduction for redress regime, or CDR, comes in. This is a regime that we propose will apply to personal investment firms. The proposals build on the consumer duty and the asset retention rules used alongside the BSPS redress scheme to try to ensure that those who create liability pay the redress bill. Our proposals outline steps to ensure firms are more prudent and set aside capital at an early stage when they have potential redress to pay. Where firms don't have sufficient capital, under our proposals, an automatic asset retention would apply. To ensure our proposals are proportionate, the asset retention proposals would exclude approximately 500 sole traders and limited liability partnerships. We believe our redress proposals offer a number of benefits. More firms will be able to provide proactive redress to consumers which have caused harm. This should reduce the time consumers have to wait for redress. In turn, this should lead to fewer firms failing because they can't meet their redress costs and help to reduce the burden on the FSCS over time. And finally, the proposal should incentivise firms to provide good advice and hopefully avoid causing harm in the first place. Our consultation also includes a discussion paper. This explores options for a broader review of the prudential regime for PIFs. That will be a longer-term piece of work and will be aligned to the outcomes we seek to achieve through other related policy projects, such as the Advice Guidance Boundary Review. In publishing our proposals for the capital deduction for redress, we recognise that there is a risk that some firms may take steps to avoid their existing liabilities before any future rules apply. This is why we published a Dear CEO letter outlining the following two parts. First, that firms have existing responsibilities and rules under the consumer duty regarding acting in good faith. And secondly, that we will be carrying out increased monitoring of firms at the authorisations gateway during this period. This will include firms applying to cancel and firms seeking to apply for new authorisations. This consultation closes on the 20th of March, so if you do have views, please do provide us with feedback and your thoughts. So that is our vision for the sector. We hope it's a vision that you agree with and can support. It's a vision focused on supporting consumers, focused on ensuring there are diverse products and services to meet diverse customer needs, and focused on making the necessary amendments to the regulatory regime to enable firms to meet diverse customer needs. It is a vision that focuses on useful information provided to consumers at the right time, empowering them to make decisions to better meet their financial future, and to make decisions where they understand the features and the reasonable risks associated with their decisions. And it is a vision where an appropriate level of protection for consumers, which is proportionate for firms, focuses on disincentivising the poorer practices we have seen in the past, and where there is poor practice, maximising the amount of redress paid by those who cause the harm. As I've mentioned throughout this speech, we think these are exciting times. There's an opportunity for you to help us shape how the sector develops going forward. So please do respond to our open consultations with your thoughts. We really do listen, and we really want to hear them. Your thoughts are critical in helping us shape our policy proposals and making them a success. And finally, I really believe that there is a huge opportunity here for you and your firms to demonstrate the value you can provide to your clients and consumers. Thank you very much.
Thank you very much, Kate. Come and join me. Come and join me. Grab a seat, and I have the iPad of doom here. Lots of people have asked questions. That's not a surprise. Several of them seem quite cross. So I may decross some of them. But one of the things, to give people time to chip in a little more and marshal their thoughts, and for questions to come through as well, because we've got moderators in Edinburgh that are taking out all the sweary words before they get sent here. Can maybe do a better job. One of the things that I'm not sure I particularly had my head around was the product disclosure regime. And I speak as somebody that's had to write key features and terms and conditions and all that kind of stuff. And I suspect for all the planners in the room and at home, they would say that where a client is receiving planning and advice, the odds on them reading any of that stuff at all is, I'm going to go for some or zero. Zero, pretty much. It's part of a very, very large pack. And it strikes me that the industry has got itself to a situation where it's becoming very precisely wrong as opposed to broadly right. If somebody were to come to you, whether it be from planning firms or from product providers or whoever else, to say, hey, listen, we've come up with a very short visual infographic base or something like that, but it can't cover every aspect of risk in it. Is that the sort of thing that you're imagining might be the next generation of engagement in this sort of stuff?
Yeah, I mean, it's a really good question.
Thank you.
So the thinking on the regime is that we really do want to embrace the consumer understanding outcome as part of the consumer duty. So what we're thinking about is a hybrid approach where there's a lot more freedom, essentially, for firms to think about the way in which they want to communicate with their customers, to build innovations like that idea into that consumer journey, and to really kind of test that consumers understand what they're signing up to. We do recognise, though, that there are some things that are key to the consumer decision, so risk, costs and charges as two examples, and that to some extent there needs to be an element of comparability across the market. So the policy design challenge that we are going to work through as part of this work is how do we get the right balance between ensuring comparability for consumers in the sector so that they can shop around and choose products appropriately, whilst embracing more innovation, more freedom for firms to communicate with customers in ways that work for their business model and their customer base.
That's really interesting. And from a policy perspective, clearly you're still a principles-based regulator, so you push your principles and then it's up to businesses to interpret those in the best interest of their client. But in these kind of areas, it does feel that sometimes a more prescriptive approach is required to ensure comparability. Do you think this kind of leaving that, last 10% to the sector, is that something that you think can survive the kind of change in emphasis you're talking about?
I mean, this is exactly what we're going to need to consult on, right? So which are the, from the consumer perspective, which are the key bits of information that you do need comparability around, and where do you want to enable more innovation to happen? Okay,
brilliant, thank you. There are so many questions here. What I'm going to try and do is do them in buckets. So I will mention some names and say thank you for your questions. If I don't mention you, I've read literally all of them. And there's more coming in. Let's talk a little bit about polluter pays. There's a few questions here. How can I put this nicely? Chafing slightly about the level of data requests and surveys and so on that you require now as a regulator, and asking, I'll phrase this nicely, do you think that will make it easier for you to more swiftly identify the polluters proactively in future? Is that a nice way of saying what you were trying to ask? I think that's what it is.
So a couple of reflections on that. So for that particular policy, we actually have a pilot out at the moment on the data that we will collect and use alongside a whole range of different sources of intelligence that we have at the FCA to be able to identify those issues early. Some firms in the room may have received that pilot information request. I'd say that it is pretty proportionate in terms of what we're adding to existing regulatory reporting requirements there, but that is out there at the moment for feedback. So if people have views on whether or not it works, then please do feed those in.
I think, and this isn't necessarily from a question, but it's something that a lot of smaller firms have said to us, is that these things take a hell of a long time to fill out. These are not always easy things to do, and if you're a large firm with a data department and resources and so on, then great. Do you think, as you refine this, I think it's a more data-driven kind of regime that we're moving towards with FCA, think things might get a bit easier, a bit shorter, more automated? What do you think see the future is for the sharing of data from firms?
Yeah, I mean, it's certainly, so being data-led is a key priority for the FCA, and we have invested a lot in our data resources and our approach to collating data from firms. So I think it's an area where we continue to focus on and really challenge ourselves on making sure that the burden that we place is definitely proportional.
This can seem like a dumb question, right? What happens with the data? What do you do with it? Is there a room and that you kind of go and roll around in it every so often? Like money in Breaking Bad? I mean, what happens with the data that the guys put in? Where does it end up?
It's a good question.
Thank you. I'm trying hard.
So the data that we take in, it feeds a number of different areas of the FCA. So we have a lot of data that feeds into our supervisory work and informs our supervisory priorities, also informs our enforcement priorities, as well as things like the market analysis function that I'm responsible for at the FCA. So it all finds a home at the FCA, for sure.
So it doesn't, I think what people want to know is it doesn't go to waste. So there's stuff happening here. Great. Quite a few people have asked versions of a question that, again, chafes a little against a product-centric regulatory framework, because I think many people in the room and at home, once again, view themselves as a lot less to do with products these days. There is one part of what they do, which is the intermediation of regulated products and services. Everything else is financial planning, much of which I guess is unregulated. It's the discussion of what your priorities and your goals are as an individual, and then the outputs from that form part of it. Is there a way, without necessarily, I don't think the people asking it wanted financial planning to become regulated, but maybe they did. Is there a way of becoming a more service-centric organisation as opposed to just products? Bear in mind, I think, that a lot of the people that are in the sort of planning end aren't using very, very complex and sophisticated instruments most of the time. I think you all tend to simplicity more than anything else. And so they're kind of feeling that perhaps regulation hasn't kept up with that change in the profession.
I have to say I struggle with the characterisation that we're product focused. I'm trying to work that one through because, I mean, most of what the work I do is thinking about how we can bring a range of services to the market to give consumers the support that they need to make investment decisions, right? So that's very much service-led.
Yeah.
You know, we're colleagues across the FCA are obviously focused on investment products, but we absolutely recognise the importance of services in our market as well, helping those consumers that need support. So I sort of struggle with that characterisation, but maybe I've missed something.
I don't know, maybe everybody else has missed something, but I think it's a great response, and I agree. I think you've been careful to say products and services all the way through. And if we think about something like BSPS, it wasn't particularly what the individual product that ended up with it. The problem was it was the advice that was the issue. We might come back to DB in a moment. Advice and guidance boundary and types of firms. A sense I'm getting from some of the questions here, I'll mention it, a couple of people, I think Ben and it says Davis, but it might be David misspelled, I'm not sure. Let's go with Davis. Kathleen a little bit, so I'm picking up all your questions here. It's hard, I think, for smaller firms to work out how they're going to be able to offer guidance services when they're already struggling with the kind of regulatory overheads that they have. And there is a sense from some of our questioners that the FCA would prefer a sector which was a relatively limited number of very large firms with whom you could engage readily, as opposed to however many thousands and thousands of very small firms which make up the sector at the moment. How do you feel about that? Would you like that to happen?
So
you don't have to answer that.
So what I would say is that there is a bit of history to particularly the simplified advice proposals that are part of the advice guidance boundary review. A few years ago, we consulted on something called the core investment advice regime. You may remember that. The feedback, and that was a proposal for simplified advice focused quite specifically on ISA investment with some investment limits around that. The feedback that we had to that consultation was that the proposals were just not commercially viable, particularly feedback from smaller financial advisors as well. So we've really listened to that feedback, and what you'll see in the proposals for simplified advice is some expansion of the thinking there. So some increases in the amounts that could be included, and an expansion of the proposed scope of situations that could be included in simplified advice. So, really interested in thoughts of whether or not that affects the kind of the commercial proposition there. I would also say that I have a competition background, and absolutely recognise the importance of a diversity of supply in a sector. Healthy competition is really important. So I don't know if that provides any assurance or not, but it's really important that the regulator enables innovation and diversity.
So I think, because I get asked this a lot, and not that I would particularly know, but I think we're saying small firms were welcome as well as large firms.
I mean, I think it is fair to say that we say in the discussion paper that targeted support is probably likely to be delivered at scale.
Yeah.
And digitally. So perhaps there is a certain business model that would be kind of better suited to that, but I don't think that's necessarily the case for simplified advice.
Okay, that's really interesting. I said we return to DB, and I'm conscious of our time. We don't have too much longer. There have been quite a few DB questions, with several of them I think are to do with individual cases, and whilst I'm pretty sure Kate knows more than anybody ever, I suspect she may not know your individual cases, so we won't necessarily go there. But one that somebody's asked, I've lost it now, but I remember what it was, is about blight, is about the concern that partly to do with BSPS, but also just to do with the regulatory concern around DB transfers and suitability, that potentially suitable transfers were choked because nobody wanted to do it. PI insurance was very hard to come by if you were doing that business. And now there are clients who are seeing that transfer values have plummeted in the last couple of years, and I think, well, why did you tell me not to do it? Because I would now be significantly worse off. What do you think about, first of all, the dangers of regulatory blight, and second of all, particularly around DB? Do you think the balance is right just now? You got about a minute now.
I'd say that if people have got particular concerns, then it's probably best to come and speak to us about that. It sounds like it's kind of quite a specific.
There are, but there's a lot of these, and something that I know we've heard before is the good gets swept up with the bad here.
Okay.
People that might have been better served by transferring, not willy-nilly, not at an industrial scale, as we all know has when things have gone wrong, that's been going on. But there are genuinely cases where possibly the best advice hasn't been given.
Sure, okay. Well, what I would say is if people have particular concerns, then they should come and talk to us about those.
Okay, that's great. One really interesting question, we had a session earlier on AI.
Yeah.
I think you
really
managed
good.
to catch that. And during that session, I think somebody mentioned the kind of regulatory interest in AI, where that goes. I think that'd be a really interesting way to finish up. So can you talk to us a little about what your views on that are?
Well, I really liked the bar chart that you presented earlier on. Is it happening? Is it in the future? Kind of not even thinking about it yet. I mean, certainly at our authorization gateway, we are already seeing business models embracing AI, and that's from new firms as well as existing firms as well. From the regulator's perspective, so we don't regulate the technology, but we do regulate the impact that the technology has on consumer outcomes. And I think at the moment our regulatory framework is pretty well equipped to deal with it. So the consumer duty, those 4 outcomes are pretty good framework to think about the impacts that the AI might have. It challenges to ask questions like, if I use this AI model, is it going to cause foreseeable harm to consumers? Those sorts of questions are, absolutely bang on, I think, in terms of working through the risks and the potential opportunities. We also obviously have the senior managers regime and the accountability that is associated with that. And I think as a sector, we're pretty well experienced in the idea that you can't outsource your responsibilities and accountability. That's pretty ingrained in the way we think about things. So, I think we're pretty well set up to embrace AI. Obviously, it's a pretty obvious answer, but there's clearly risks and clearly opportunities, as many of the expert speakers have talked to us about today.
That's excellent. Listen, we are out of time. It's not the easiest thing for regulators to come up and speak in front of rooms like this, so please give warmest of thanks to Kate Blatchford.